Sometimes just doing a little bit of homework might save you $3 million or so. What's going on, guys? This is Adam D'Angeli from the Rescue Michigan Coalition, and in this video I'm going to follow up on a point I made in yesterday's video talking about the race for governor, in which it has become a story that Gretchen Whitmer has been allowed to flout campaign finance limits and therefore raise more than $3 million for her campaign from individual contributions over and above the campaign finance limit. We're going to talk about whether or not this is actually legal, and the simple answer is it's a matter of opinion. And ultimately right now, the standing law is what was decided by the Secretary of State. And to my knowledge, that has never been litigated. And certainly under these circumstances, it might actually be ripe for litigation. And we're going to talk about exactly what that might look like. So if you're not familiar with the story, I'll put the screen up. This is the story that came out in Bridge Magazine yesterday. GOP strategists' effort to recall Michigan Governor Gretchen Whitmer have backfired. And this article, by the way, speaks to the mentality of GOP strategists and shows how intellectually bankrupt they really are. Let's go through the story and you'll see what I mean pretty quickly here. So they explain, the efforts to oust Governor Gretchen Whitmer have allowed the first-term Democrat to shatter fundraising records because of a decades-long rule exempting contribution limits for officials facing recalls. Now, multiple Republican strategists are asking those behind the recall efforts to stop. Now, let me point out here, this is Bridge Magazine. They are technically nonpartisan. They are clearly left-wing in their bent. And why a Republican strategist would be talking to Bridge Magazine in the first place is an important question. But beyond that, the Republican strategist, and they quote this one gentleman, Fred Wzolik, he's identified as working as a campaign advisor for GOP gubernatorial candidate Tudor Dixon. And you may also recognize his name in the Unlock Michigan press releases. He's their press director. And he says all these grassroots conservatives who want to get rid of Whitmer need to get with the program that they're currently making it harder, not easier, Wzolik says. Notice Wzolik doesn't even consider the possibility that these quote-unquote grassroots conservatives that nobody has ever heard of might actually be operatives doing exactly what they were intending to do, which is to exempt Governor Gretchen Whitmer from campaign finance limits. In fact, this one individual has now filed for recalls against Jocelyn Benson, the Secretary of State, and Dana Nessel, the Attorney General. So why on earth he would assume that just saying, hey, we got to tell all the conservatives to stop doing it is going to have the effect it's intended, even if it was, calling attention to this would only encourage the Democrats to find any other putts to file a recall petition against them. But there they are. And here's the explanation for this. So it says candidates facing recall efforts in Michigan do not have to file the state's individual campaign finance contribution cap of $7,100 and $7,150, according to a 1984 ruling by then Secretary of State Richard Austin, a longtime Democrat. And so according to Monday's campaign disclosures, Whitmer's top contributors include Mark Bernstein, a personal injury lawyer, and a member of the University of Michigan Board of Regents, who himself gave $257,000, and the governor of Illinois, Pritzker, gave her $250,000. There's another article on MLive, same story, same slant, and it's also saying someone at the Stryker family also gave another $250,000 to Gretchen Whitmer. But is this going to legally hold up in a challenge? Well, let's look at what a challenge might look like. Let's start by doing our homework here. There's a link here to the 1984 ruling by then Secretary of State Richard Austin, a longtime Democrat. And here is that ruling right here. So let's first read the letter, and then let's try to understand the context of the letter, because in a legal dispute, let's say you were a Republican candidate for governor and you wanted to sue Gretchen Whitmer to have a declaratory relief against this policy. You wanted to say, no, this policy is wrong, and here's the circumstances. What you'd want to do is look at what they're arguing in this letter, and then see, number one, can you refute their arguments directly? And number two, can you show how this specific instance might be distinguishable? And we're going to look at that right now. So here is the letter. So this is coming from Brooks Patterson, prosecuting attorney. This must be before he was the county executive, but now he's the county prosecutor in Oakland County. And Patterson has written to the Secretary of State, Richard Austin, and you can get the context of it by this response from the Secretary of State. So Secretary of State responds to Patterson, Quote, in your letter of November 17th, 1983, you request that the Secretary of State issue a declaratory ruling on the question of whether the contribution limits of Section 52 of the Campaign Finance Act are applicable to contributions made to an office holder who is the subject of a recall election. Your request was made subsequent to the dismissal of your action against Senator Mastin's candidate committee in Oakland County Circuit Court. The dismissal was based on your failure to seek a declaratory ruling from the Secretary of State prior to seeking declaratory relief from the court. So what's happened is Brooks Patterson has sued Senator Mastin, and the court said, sorry, you didn't go through the proper procedure. You need to first check with the Secretary of State, ask for a declaratory ruling. So that's what Patterson has done. And so he quotes his letter here. I am requesting that you specifically rule whether Section 52 of the Campaign Finance Act applies to a candidate committee of an office holder subject to a recall vote. I am sure that you are aware of the October 7th, 1983 letter from Mr. Philip T. Frangos, Director of Hearings and Legislation at your office, which advises that the provisions of Section 52 do not apply to a candidate for recall. I disagree with that ruling and request that you reconsider it and issue a formal declaratory ruling on that issue. So here's what's happened. His legislative staffer says, yep, campaign finance limits don't apply to recalls. And what's going on? Let's understand the context here. What's this recall against Senator Mastin? Now, some of you might be familiar with this issue. I personally was pretty young in 1983, and in fact, didn't move to Michigan until 1999, so I did not know about this, but thanks to the magic of the internet, we can look it up. It turns out this was a huge story back in 1983. Phil Mastin was a Democrat state senator. He was the first ever Michigan state legislator to be recalled from office. He was serving in the first year of his first term when it occurred, and it happened because he voted to raise taxes. There was a big tax increase that the legislature passed, the governor signed. Adjusted for inflation would be a bit more than $1.4 billion. That's almost as big as some of the tax increases they've tried in Michigan these past few years. And in his election campaign for governor, Governor Blanchard had promised he would only turn to a tax hike as a last resort, but then that was the first thing he did within a full month in office. He proposed a massive state income tax hike. Democrats held both chambers of the legislature when the tax increase was enacted. So Mastin was recalled. You see here the votes to recall were overwhelming. In fact, this was when the Michigan Senate became Republican, which it has been ever since. So that's the context of the recall, although there's another important detail here I did not mention, but we're going to come back to that. So, Democrat Senate, Democrat governor, Democrat Secretary of State. Brooks Patterson is suing the governor, or suing the Secretary of State for, well, he sued the candidate, and now he's asked for this official decision. So, here's the decision that the Secretary of State makes, and all he basically does is say, the staffer had the correct conclusion in the first place. So he then just simply cites the letter. So he is now reading the letter that his staffer wrote on the opinion. Quote, pursuant to Section 12 of the Michigan Act, I'm not going to read the act numbers, it's not important. A member of the legislature is a candidate for state elective office. However, elective office is defined in section yada yada as a public office filled by an election except for federal offices. Since a recall vote does not fill a public office, it must be concluded that the candidate committee of an office holder subject to a recall vote is not, quote, a candidate committee for a candidate for state elective office. Now let's think back to the present tense here. Gretchen Whitmer is running for re-election, filling her campaign coffers with unlimited contributions for her re-election. But let's come back to that in a minute. We're gonna finish up this letter and then we'll get to the legal analysis here. Therefore, Section 52 does not apply to contributions received by an office holder who is being recalled, provided the contributions are designated for a recall election. Provided the contributions are designated for a recall election. In an election to fill an office, the opponents are two or more candidate committees operating under the same restrictions. For example, in a state senatorial election, contributions to each candidate are limited by Section 52 to $450. That's back in those days. It's a lot more now. Unless made by an independent committee, political party committee, or state central committee of a political party. Contributions from these committees, however, are subject to other restrictions. So what he's going to get at, and I guess I'll just continue on, he says, this is not a fair playing field because if you're being recalled, the recall people can raise unlimited money, but the person subject to the recall can't be. So here he says, proponents of a recall measure are required to file a statement of organization as a political committee. Contributions to political committees are not subject to limitation under the Act. If Section 52 were to apply to contributions received by the candidate committee of a state elective office holder facing a recall, the opponents in a recall election would be operating under a different set of rules. Such an interpretation would undermine the open and fair election policy otherwise promoted by the Act by allowing the political committee advocating the recall to engage in unlimited fundraising while severely limiting the office holder's ability to raise money. This result, which is inconsistent with the Act's purpose, is both absurd and unfair and could not have been intended by the legislature. And that's just a politician lying right there. Just, could not have possibly been intended. Says who? Says you. How? How do you know that? But that's what they say. The result, it says, consequently, Section 52 cannot be construed as applying to contributions received by the candidate committee of a state elective office holder facing a recall election. So a couple of points here. First point, it is absolutely absurd to assume that being unfair precludes it being something that possibly was the legislature's intention. But secondly, let's compare the circumstances here. In this case, there was an actual recall campaign. In fact, this, I would say, is the most important thing that needs to distinguish what is being discussed in this case versus what is being discussed today. Now, here's that important detail in this recall election. I want you to notice the date on this letter, January 3rd, 1984. And it's in response to a letter dated November 17th, 1983, and a follow-up to a letter on October 2nd, 1983. Let's look at the history of this recall. The election to recall him took place on November 22nd, 1983. In fact, I think they even have the date. The signatures to recall him were turned in on July 26th, 1983. What that means is that when this letter was written and when they were discussing a candidate being the subject of a recall, it means the signatures were collected, the signatures were approved, and the recall, when this opinion was sought, was imminent. And then this final letter occurred after the recall election was over. That is not the same as any effort to recall Governor Whitmer or Nessel or Benson today. I'm not aware of any active recall election petition right now that's even been approved by the Board of State Canvassers, let alone actually collected the requisite million-plus number of signatures, an impossible sum to collect, incidentally. So, does Gretchen Whitmer have the same lack of restriction on campaign finance? Look at the conclusion. What they're saying here is that, in essence, it would be unfair to the office holder if the opposition could collect unlimited money when the office holder couldn't collect unlimited money in his or her own defense. What's being applied today is that the simple act of someone filing for a recall, having no signatures, having no approved language, just any old citizen entity can apply for a recall, file a motion for a recall, and boom, suddenly the incumbent can collect unlimited money. You have to take this to its logical extension. What would stop this from happening in every other political race for elective office? What would stop anybody, say you wanted to support an incumbent, and keeping it to yourself, you file a recall against them, knowing that all it will do is allow them to collect unlimited contributions without limitation. That could happen for each and every elected office in Michigan. That would be the most obscene incumbent benefit ever imagined. All you have to do is file a piece of paper with the Board of State Canvassers, and suddenly the incumbent can raise unlimited money while the opponents cannot. That is the reality here. And they have they cite here the Buckley v. Vallejo case, which was a landmark Supreme Court case about what First Amendment rights people have to get involved in politics, what constitutes electioneering versus political speech versus free speech, issue advocacy, and so forth. And quoting this, they say it would be absurd and it would be unfair if because the Vallejo decision clearly said you have to have a fair playing field in the elections. It would be a discrimination against challengers, and that would be unfair. Well, what this is being practically applied for now is to allow incumbents to raise unlimited money. All they have to do is find a warm body on the down low, on the hush hush, to file for their recall. And suddenly their campaign finance limits go poof. And the challenger couldn't even make that same play because they're not the incumbents. They're not subject to recall. How fair is that? So what would a lawsuit against this look like? I would submit two things. Number one, this decision clearly should not apply because Gretchen Whitmer, Dana Nessel, and Jocelyn Benson are not subject to recall in the sense that this letter addresses. Nobody's collected any signatures. Nobody's submitted any signatures. There is no imminent recall election present. And that by extension of this logic, that all anybody has to do is have someone merely file a piece of paper calling for a recall, that gives an extraordinary and obscene unjust benefit to the incumbents. It is incumbent protection at its finest. And who could bring such a lawsuit? Anyone challenging an incumbent for office. Anyone could. If you're running against an incumbent as a primary or in the general election of an opposing party. Now, it'd be best to have standing if you were a candidate for governor of Michigan, because Gretchen Whitmer has admitted in the news that she is actually abusing this decision to raise money. She's quite proud of it, in fact. He says, right here, let's see here. Where's the quote? We're taking recall efforts seriously. We're exempt from the campaign finance limits because she's facing the threat of recall. Speaking to reporters Tuesday, Whitmer made no apologies. We need to reform when it comes to political contributions, but as long as the rules are what they are, I'm going to make sure I always exploit the rules as much as I can. I'm going to run hard like I do whenever I set my mind to something, and I try really hard to set my mind to something because that's the only way I can stay focused on it. Yeah, this is what's happening. This is in writing. Any candidate for governor could use this. I hope that some of these campaign consultants don't just take the media narrative at face value. Don't just assume that when the rules are being used against you, that your first reaction is to blame the grassroots. Blame the grassroots. Don't blame the opponent. Don't challenge the law. Blame the grassroots. Don't assume that this individual, and in fact, it's just one person that filed this recall petition against Whitmer, against Benson, against Nessel, is a grassroots conservative with the purest of intentions. No, you should look for, how can I use this to my benefit? That's how Democrat operatives think. Why don't Republican operatives think that way? But I digress. So, hey, feel free to pass this message on to anyone you might know running for governor, or perhaps Attorney General, or perhaps Secretary of State, perhaps even challenging an incumbent. Because you might actually get a resolution on this that might actually cost Gretchen Whitmer north of $3 million. By the way, another argument they could make is, as it noted in this letter, where was it here? Right here, section 52. I don't have my mouse cursor on the screen here. Bottom of the first paragraph on this page, where it starts. Therefore, section 52 does not apply to contributions received by an office holder who is being recalled, provided the contributions are designated for a recall election. Get declaratory relief that compels the governor to put that money into a separate segregated fund that can only be used in defense against a recall. And, of course, it should also require those funds can't be spent until there is actually a recall on the table. Otherwise, obviously, she's just going to intermingle her re-election campaign with the fantastical recalls that will never materialize, because it is literally impossible to collect more than 1 million signatures in a 2-month span across the entire state of Michigan. It will not happen. The only people that have filed for recalls are either people that have no clue what they're doing and are motivated only by their passions, or Now perhaps we must take the possibility seriously that these are Democrat operatives doing this exactly for the purpose of allowing Whitmer and Benson and Nessel to raise unlimited funds and therefore create a grossly unfair playing field against their opponents. So if you like this kind of content, be sure to like, share, and subscribe. Pass the word on, because you know what? There are things that people can do to fight back when they know how. So here at Rescue Michigan, be sure to check us out, rescuemichigan.com. We have, I think, some bold, incisive content on some of the political issues of the day happening in Michigan. Thanks for watching, everybody. Till next time, peace.